So I've got a presentation prepared and everything, but I want to understand who's who. So if just a couple of you, if you can tell me what you do, then I know where I can actually discuss, which point of view I can discuss this topic that is also very massive because it covers a wide array of different rights. And you can't speak about IP without speaking about contracts. You can't speak about contracts without speaking about even just general morality and moral rights and everything else. And you can't speak about all of this without speaking about legislation. So it's very all encompassing. So if you can just tell me who's who and what you do, I'll come to you. Okay. All right. Okay. So singer, artist management. So you're creative. Okay. Okay. I think you've already mentioned what you do. Okay. 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 Somebody from the back. Yeah. Okay. All right. Can I know this side? These are the wigs, the suits. These are the suits that are that. Okay. So because we've got such a wide array of people here, I think, okay, this is just I'm a lawyer, so it's confidentiality and a disclaimer. So everything we share here, it's, the presentation belongs to us, and, whatever we share is not legal advice. So I just think I need to say that at the onset. If you want legal advice, you have to get it tailor-made to what you need and what suits you and what your issues are. Because like I said, with legal issues, it's diverse, it's different, it differs from person to person, depending on where you are and what the issues you're faced with. So so first and foremost, what is music? We all understand that music is powerful and that it has the ability to bring life to any moment. I'll give an example of just the other day, and I keep mentioning it to my big wigs here that are in the audience, is that, when we were all downstairs, when we had wrapped up on Monday, the one biggest component that brought attraction to the Netflix stand was the fact that there was a DJ and the DJ was playing music. So what that did was that it congregated everybody to a specific area, and it brought the life and soul to the end of the event. That is what music does. Music has the ability to bring life. It has the ability to bring people together, even apart. It has the ability, and it exists in most of our memories. And any sort of event and place and time, you always attach it to music. The same way you'd attach it to taste or smell, but music is very, very integral in that. And it transcends language, race, culture, and is universal. And it also transcends barriers. Wherever there's a celebration, wherever there's sadness, there is music. So then we've spoken about what music is. Now we're talking about what IP is. IP is intellectual property. It's the creation of the mind. It's what you have created with your mind. It's what you have developed. It's what you have invented. So it's a bundle of different rights that speaks to what you've created. So it can take the form of literary, artistic works. It can take the form of designs, which would be this beautiful thing, remote. There's a design element to it. It takes the form of patents, it takes the form of names, symbols, images, which are then trademarks. So speaking of the literary and artistic works, that then speaks to copyright, which for most musicians, most creators, that is the most important aspect of IP for you. Okay. In music, IP rights are mainly copyrights and trademarks. So I mention trademarks because that's the brand, that is the slogan, that's the image that you have, that's what you're selling to people. So when someone thinks about let me use Uncle Waffles. Uncle Waffles is a brand. Uncle Waffles can trademark the name Uncle Waffles. Uncle Waffles can take that name and create over and above just the music, and create assets from using that name. I mean, we've seen with the KFC deal and the fact that she's now got a burger. That is part of what your IP that you've created and the trademark that you have as a brand allows you to then create and do. And so what intellectual property does, it also serves as security for musicians, creators, and rights holders. So right holders are those people who they didn't necessarily create the music, but they've got the right to it. So they wouldn't have created the works, but they have the right to it. So somebody else created it, either they've licensed it, they've sold it, they've assigned it, but they haven't created that. So I'm giving you guys a background and a foundation basis so that you also understand, so that when we have a discussion around, the future of music and IP, then you at least understand the terminology so you're not too lost, right? So IP does play a very pivotal role in the music industry because the music industry, the backbone of it is intellectual property. In particular, it is copyright. It is, and what it does is that it creates the opportunity and ability for creators, be it composers, singers, beat makers, producers, rights holders, to earn an income, which is then the commercialization, which speaks to what I mentioned around the trademark. That's commercialization, how you make money from what you've created. The music itself, how you make money from what you've recorded and what's out there, that's commercialization. Okay. Okay, I've just spoken about that. So it speaks to sale of music, the use and enjoyment of music, licensing of music, performance of music, merchandise, etc. And also, I apologize, my presentation is boring. I'm not a lawyer. I'm a lawyer, I'm not a creative. So that's why it's black and white and basic. There are no, colorful things happening there. So the two common types of IP in the music industry are copyrights, particularly literally and artistic works, and trademarks, which is the logo, name, slogan, brand. So I've put in there, a slogan as well, because I'm sure you've also realized that some DJs, right, they would, like DJ Khaled, we're the best, right? In every single song, he'll say, we're the best. So he's trademarked to we're the best, not only from a trademark in terms of a logo, but as a slogan so that other people can't say the same thing in their songs. And what it also is that it's part of his copyright, that only he can say it in the context of the music that he's creating. So if he says, and the way he says it, so I can say I'm the best, but I don't say we the best because I don't speak about myself in third person, you know what I mean? So he's created that kind of persona, and that's a copyright element for him that he owns. So if you go into a song and all of a sudden you say, we're the best, the way he said it, he could come to you and say, that's my slogan, that is mine, I've created this and I've got protection around it because it is something that I have created, that I have built goodwill, that I have built a reputation around, and you want to benefit unfairly from the goodwill that I have created in this one statement, we're the best. Okay, so with copyright, it is the backbone of music, and it regulates the usage and enjoyment of the works. And it is also the ability, oh, look at my presentation there. Okay, it's the ability for the creator and the rights holder to earn, which is then the commercialization. And it's important for the music creator because it protects the sound and the written work. So the recording itself, the sound recording, and the lyrics, the composition, that is what it aims to protect. Okay, so in the music industry, these are the types of copyright that you find. That would be the lyrics, the composition, the sound recording, the video, even the photographs. So if someone takes a picture of you, you use that as artwork for your cover, that is part of copyright in the music industry because that forms part of the artistic and the visual aspects of copyright. Do you want me to get into greater detail, or are we happy? Are we good? Okay. So in terms of the copyrights in the music industry and the future, there's a lot of technological advances that have happened in the music industry. If you look at how music was recorded, how music was released, maybe even 10 years ago, 5 years ago, to now, it is completely different. How people also create the music is completely different. How people interact and engage and even consume the music is completely different. And I know everybody's burning topic and what everyone wants to discuss is artificial intelligence and how it affects the music industry and whether it's something that we should be scared of, if it's something that we should embrace. And I've had a lot of clients come to me and like, what happens if somebody uses my voice? What happens if somebody, takes my lyrics and creates a song out of my lyrics, but they've generated it using, software and using using computers and all this, artificial intelligence. And my view is always that if you've created goodwill, the goodwill is something that you own. your voice, there's something we call, name, likeness, etc., which is, and your voice as well, is that it's protected. So if somebody wants to come and take your voice and use it to create something out of it, that's an infringement of your right, but it's not necessarily infringement of a copyright. So it's all encompassing. That's why I say to you, you marry a lot of various rights to create one right and the protection in that right. So with artificial, so I always tell them, your voice is your voice. If somebody wants to create a song using, create something using your voice, you can fight that, because it creates the impression that you're the person that has said that. It creates the impression that you've released this. It creates the impression that you have, you've sung this particular song, even though it's not you that has done that. So even with artificial intelligence, and I think we all saw the whole saga with the Drake and the Kanye West, where the producer created full-length songs by Drake and Kanye West using their voices, and also the way that he even created the lyrics were very similar to how they would have done. So for me, and this, because it's all very conceptual at this point, no one has a lock stock answer on how artificial intelligence works and what it is. I break up all those different elements. So for me, the copyright, the lyrics that he's created, he's got a copyright to that, because he created the lyrics. So if Drake comes and says, but it's my voice and the song is mine, it's not your song, it's your voice, yes, but the lyrics were created by somebody else. The copyright in those lyrics and the composition belong to that person who created it. The voice, then he can come and say, but this is my voice, you're using my voice, and okay. Yes. Yes. Mm. Look, I mean, the Marvin Gaye estate was successful in that case. I mean, it also won against Robin Thicke, because they did take elements from his melody, and a melody is also protected by copyright. So that's why you've got people like your publishers, where they protect all of these elements. So it's what he created. If you're humming something and it creates a sound and it creates a mood, it creates that element, you own that humming, but you also have to reduce it to something tangible. Because if I'm humming something and I'm walking here and somebody else hears it and like, oh, that sounds nice, and then they go and record it, then they've taken an additional step and recorded that. So until I've also created in a tangible form, then I can claim it as my own. So Marvin Gaye created the melody. He created, there was the whole, what you're saying about the mood and the element of it, that was something that was created by him in that studio, recorded it, it's in tangible form, it's out there for everybody's consumption, and somebody takes that, you have to get clearance for it. You can't just use people's works. And I think that's also, just to touch on, then that's where the issue around the new copyright amendment bill comes in, where there's the issue around fair use, where people are saying, we don't want fair use to be used in our country, because fair use then allows you to use somebody else's created copyright, but I mean, to a certain extent, because it's not an open-ended right. But the problem is that now you have to prove that this person used your right. And if I can say to you, look, I used your melody because I just wanted to try and sample and see if this would work, but the minute I then release it and there's a level of commercialization, then you can come to me and say to me, but you've commercialized this without getting my consent. But the issue with that is that now I have to take you to court. We have to go fight, and there's a whole dispute, versus what we currently have in South Africa with fair dealings, where fair dealings allows for a limited usage without necessarily getting a license. So things like, for news, public interest, education purposes, etc. So that's why there's also those issues, because, I mean, I'll use Tracy Chapman and Nicki Minaj, where Nicki Minaj sampled, and everybody knows Tracy Chapman and her music. She is anti, anybody sampling, anybody touching her music. So Nicki Minaj did a clip, recorded a song, and then she went on a radio show and she played it. And the issue was that you played my song, you didn't get clearance, you sampled me without getting the relevant clearance. This is actually copyright infringement, because I didn't provide you with any sort of clearance for it. And Nicki Minaj's argument was that no, but it was just for sampling purposes. It wasn't commercial. It wasn't necessarily commercial. But the argument from the judge in the ruling was that the minute that you released it on radio, that became a commercial asset that you released. So that is then that becomes a problem. Hence, she lost that case as Nicki Minaj. Okay. Any other question? Okay.
Actually, I have a question regarding ghostwriting.
About ghostwriters. Yeah.
It's something that really, like, I think it's very tricky. For example, there are real rumors that someone writes for Drake, for example, and it doesn't deny it, but not accepts it. Um, since the lyrics are property of someone, if I close a deal with you, say, okay, I'm gonna pay you $1,000, and I'm gonna write the lyric, and that thing makes $1 million revenue or profit. How can you claim back that right?
It depends on what the agreement that you enter into, right?
When there is no agreement, that's my question, because there is some moments in which the person is being taken advantage of because they know that they're creatives. I can use your work and then I know what I'm gonna sell. So can that person claim that when she understands that she was ripped off?
So in our law, right, in South Africa, in order for you to transfer IP, it has to be in writing. So you can't transfer IP just, conceptually. It has to be in writing. That's why, a lot of people find themselves in hot water. You sign an agreement, you don't realize what you're signing, and you've ultimately signed off all your rights to whether it's a song, whether it's, even yeah, like your lyrics, for example, right? What you're speaking of now. But the thing is that, but you can still argue that, but I paid you for it. I said to you, I want you to write these lyrics for me. I paid you, you accepted the money, and you went on your merry way, right? But the problem then becomes that once it does become big, then I can argue and say, but I didn't sign. I didn't sign anything to give you, I didn't assign my rights to you in that copyright. I sold it to you for you to use at that particular point in time, and I still feel like I'm entitled to the rights to that particular song. And if you also then haven't, necessarily, reported the songs with the various, CMOs, and you haven't also written your splits, etc., then it also creates an issue in terms of proving that. So with there's nothing wrong with ghostwriters. A lot of singers don't write most of their songs anyway. Somebody else writes the song. The difference is that you know who the songwriter is. But with rappers, because rap historically and culturally, you're supposed to write your own music, and if somebody else is writing it for you, then you're not authentic to the art and the culture. But it doesn't mean that Drake doesn't own the lyrics, because if he's paid for it and you've signed an agreement to say you're transferring the rights in it, I can't come back and say, okay, now that the song is a big song, I want to earn on it, because I would have transferred my rights. So that's where comes in where you're the creator and the rights holder, because the rights holder becomes the person who didn't create it but now owns that rights and holds the right to it. So now it's theirs now, so they can do with the lyrics whatever they want. So you can't come back and complain and say, I only charge you a thousand US dollars now, pay me more because the song is now worth 10 million US dollars. So that's why you have to be very mindful and careful with what you enter into. And also, if you're trying to argue and fight a Drake for a song, you're going to be exhausted in legal fees. Because you can definitely argue it, you can take it to court, but you are not going to have the financial capacity and muscle to fight it. So that's why at the onset, you ensure you could even say, look, I've written the song for you, I'm getting an upfront fee of a thousand US dollars, but I still need to get some sort of credit within a writing credit, so that I can earn royalties from it, so that I can give it to my publisher. I've got the publishing people are here, and they can then collect on my behalf. And that when there's any sort of sync deals that happen, be it with TV ads, etc., then I will still earn from it. But you, as Drake, then it's your song, but I'm still earning from it as a writer or composer in that particular piece of work.
Yeah, yeah. Thank you for the clarification. I just put this question because I believe that in this situation, both sides can be unprotected. As you said, it has to be written.
Mm.
So if I took the lyrics without actually the person that gave the lyrics to me acknowledging that through
Mm.
writing form, then I'm vulnerable later on for that person
Yeah.
claiming back their rights.
Yes, because then that's copyright infringement. If you take something that no one's given you the right to, you've infringed on their right, because they've created it. It is their invention, and by you taking it and using it, you're infringing on a right that belongs to them. Yes, really. So, so the thing with copyright, right? And you're saying fall from the sky. It didn't fall from the sky. There's a reference point, right? You can either say the reference point either falls outside of copyright protection, that it's sitting in the public domain and has been in existence for more than, the life of the author plus, plus I think it's 90, right? It's 90, 60, yeah, 90 years, right? So it falls outside of that. Then that is something that is open for anybody to use, that you can use it. But that requires at least, if we're saying the life of the author plus, there's like 100 years, So let's use like Beethoven or something like that, right? So we generally say it would be out of copyright, right? Because you can then use the song. So if you're going to take somebody's lyrics and expand on it, I mean, a lot of people do it. They reference it. You use one lyric in one line in your own song, you use it. A lot of people don't argue that because it's not, you're just like, it's just, it's a lyric, it's a line, it's not anything that takes the song neither here or there. Am I going to really earn from that? Is it the full encompassing? No, it's not. So you can stretch it in that now you create a derivative work from something that already exists. So if you take, let's say you take a melody, let's use Sister Nancy. I'll use Sister Nancy because she's a big example, the Bam Bam song, right? What Bam Bam. It's been done in like there's various derivatives of that song. Jay-Z did a similar song. Her story is that she wrote the song, she recorded it, she was in studio very long time ago in Jamaica somewhere, and they recorded the song. She didn't get paid for it. There was no contract, nothing happened. She just recorded, was excited, wanted to be a singer, and she was also working in a different industry. I think she was a nurse or something like that. Recorded the song. Then what happened was that then the producer then took it to a radio station in the US, but this was 10 years after it was recorded, so it wasn't an immediate thing that had happened. We record the song today, in 2 weeks you then take it to the radio station. It was 10 years later. She's sitting in Jamaica. The song is massive in the US. Everybody's singing the song, and she's just like, wait a minute, but this sounds familiar. This is my song. This is my voice. This is me. And the producer was like, no, but I mean, we created the song together. I've got the rights to it. It's my song as well. And then she obviously argued it because then she saw the samples, the Jay-Z using the samples. There were a lot of ads that were using the music. It was a massive hit that everybody was using. And she managed to obviously argue that it's her song and she should get paid for it. And your Jay-Z's, all the ads, everyone else, they back paid her for 10 years of usage in that particular song. So all I'm saying is that you can try use people's IP and use their copyright, and some people argue it, some people fight it, but others won't. But it also depends to what extent that you're using it. It depends to what extent you're sampling it. Because like you're saying, with hip hop, there's mixtapes. I'm a hip hop head. I love hip hop, so I'm like, so there's mixtapes. There's, that when the culture of we're going to rap over somebody else's beat, and then somebody said something yesterday that I must touch on, I'm going to touch on that. So we rap on other people's beats. Sometimes you even use a verse from somebody else's song, or even use a chorus from somebody else's song, a melody, etc. And it's okay because it's released in the streets. But the minute you commercialize it and put it on Apple Music, then it gets flagged because that's copyright infringement. You haven't received any sort of release from me or clearance from me to use that particular song. And just to speak on that with the copyright infringement, somebody was saying, they listen to beats online and then they just tweak it a bit, and then, just to create a new thing. And it's like, that's copyright infringement. You can't just tweak it a bit, and just because you tweaked it a bit, you still have to get the necessary clearance. So you can't just use people's intellectual property without the payment. So like you're saying, how far can you stretch it? You can stretch it as far as your pocket allows you to stretch it, because if I want to fight it, then I will fight it and I will have a valid claim against you, even though you're saying, no, but I actually heard it from, I got the song, no, I heard another guy who released the song before I heard yours. I was like, no, but originally I can prove that I released it first, because that's also a paper trail. When did you release it? Who's the first person to release it? How long ago did you release it? Then you're proving your case and saying this person might have reference from you. Then it becomes, then you prove that as well, and you say, but it's my right, and it's as simple as that. So you can't just take chances and say, I'm just going to take something and hope for the best and cross fingers. Okay. Anybody else? Okay.
I just wanted to ask, because it kind of ties into these two guys' questions. Are you aware of the group of lawyers
Sorry, can you say that again? Group of lawyers who?
They basically got a programmer to brute force every melody possible, like every permutation of like melody possible, and they've saved it to USBs, meaning they've like made a physical product
Mm.
out of it, and they are presenting it as um, something to be used in these kind of lawsuits where people say, oh, this person copied my melody, but it was basically to say that, look, we basically created every single melody, and we're putting it in this sort of creative commons realm. What do you know about this story?
I don't. That's the first time I'm hearing of it. Yeah.
Pretty old story, but
Mm.
it's been doing the rounds in social media in the last few weeks.
Is it?
I was just curious if you knew about it.
No, I'm definitely going to look into that because it also, I mean, if they've created it and they've used the software and they've put it on a USB and they're saying it's theirs, then you're going to have it's theirs. Do you get what I mean? Because they would have created it. Unless you're saying they've taken melodies and extracted them from everywhere else and then put it in one place, and then you can now identify using that particular USB to say this belongs to this person, this belongs to this person, so that it makes it easier to litigate and under circumstance. I'm not, is that what it is?
So basically what they did was, there's basically a program that people often use to crack passwords.
Okay.
Basically auto-generates a whole bunch of digits back to back to test out passwords. They use that same technology to then basically generate a whole bunch of melodies. Any melody that's possible and is protected under law, and what isn't protected under law currently. But they basically created every single melody possible.
Mm.
And they've said, because we created everything, you can use our USB to fight against bigger corporations.
Oh,
You copy my melody.
okay. But the magic word is that you said created, right? They have created. So, but they're putting out in the open market. So they're letting other people use that as a sense of, for a form of defense against. Okay, well, I mean, they're giving people the right to use it. So it's almost like white labeling, where you white label, you allow people to then use it, or what do they call it? What do they call it? That the music on YouTube that isn't. What is it? What is it called? No, not whitelisting. What is it called? Um, what? No, no, it's called, there's a thingy, another word for it, man, that they use on YouTube that's not, I forgot the word. Royalty free, yes, yes, thank you, yes. That's the word, yeah. So, I mean, they've said you can use it. It's almost like, with artists. There's, I forgot his name now, the particular artist who created works, and he said people can use the works any way that they want to use. So you can print it on a T-shirt, you can print it, make a copy, hang it in your house. But the only difference is that you can't sell it. The minute you sell it, then it will attract that fee. So what they're basically also doing is that they've created this and saying the minute, well, I mean, this is without having all the facts, that they've created this, and the minute you want to use it as a form of defense, then here it is. But what I'm sure is that they won't allow people to use it from a commercial point of view. So the minute you use it commercially, then chances are they will then want to charge you a license fee or for usage of it, or royalty for usage of it. But I will look into that. I'm not very familiar with it. Any more questions? Ryan, you look like you want to ask a question. Okay.
I don't know if it is the right call or not, but regarding the shares, the share, we have a music, right? And then we have the singer, we have the producer, we have the lyricist. So how is, because I know that when you submit the music to the distributor, so you also have to put the lyricist and so on. But my question is, how is this share calculated?
The split, yeah.
Split.
There was, we always speak about this because some people say it's automatic 50% for the producer, automatic this, that, and the other. As parties, you have to agree, right, according to the contribution to that particular song. So it's not an automatic science that you say just because you're a singer on the song, you're gonna get 33%, and there's maybe three of us now, we're all getting 33.333%. You can say, look, my contribution was just to, the chorus, and maybe contributing to the chorus only amounts to like 5% of the song. And somebody else says, because I composed, I'm the beat maker, I've made this beat, then I want a bigger share of the, because it's throughout the whole song. Then the producer comes in and says, no, because I did this, that, and the other. So you agree to the splits. It's not a science where you just say automatically 50%. And somebody did say something about it's an automatic amount. It's not. You would have to agree to that.
But then when this situation like the one that you said, that you didn't agree on nothing, because it happened a lot.
Mm-hmm.
You finish the song, now you have to distribute it, and then no one discuss about sharing.
The split, yeah.
Split, and then you are there, you have to make the decision. So you have to go back to talk to each one that was in the past that you didn't.
Mm-hmm.
So
Yep, and that happens a lot in hip hop, because people go, because like I told you, I'm a head. So some of my clients are hip hop people, and I always fight with them, because I say to them, guys, before you jump into the studio, because what they'll do, they'll go out, have a good time, and they go to someone's studio, and then they will then record a song. Then the song comes out and it's a big hit. No one knows how much anyone owns, because they didn't discuss the splits. No one was interested in the splits, because we're rappers. We're just making music. We're vibing. We're enjoying this. But you have to go back to all the parties, because now if one of them goes and reports it as at a SAMRO, for example, and say this is a song that I wrote, then they see that there's other people who are featured on the song. Then they're gonna ask, okay, so what's the splits? And I can then go to SAMRO and say, I'm preventing you from actually distributing to this person any royalties, because I'm actually also on the song and I'm supposed to get my share because it wasn't in writing. So you have to do your split sheets. That's a very important, I think anybody who steps into a studio, just as long as you're contributing to that song, make sure you've got a split sheet. If you're not going to have a split sheet, then you're going to have to fight it. And fighting it means going to court. It means coming to me, and then I'm going to charge you the big bucks, and then it's a big problem. You get what I mean? So you have to have your split sheets. But you'd have to go to everybody and basically backtrack and go do the process backwards. And I know it's always so difficult to do it at the onset, because you also don't know the contribution, how it's going to pan out. But after you've recorded the song, you can just sit there and, download the split sheets and all this information that you can get. I think even on the SAMRO website, they do have split sheets. Download that, fill it in, and you're good to go. Pardon? Oh, time. Oh, okay, time. Okay. Yes. Okay. Okay, so I'm going to answer the first one first, and then the second one you must ask it again, right? So with the first one, like you said rightfully, the copyright is an automatic. The minute you reduce it to any sort of tangible form, then you've kind of created that copyright, and you've created the protection for yourself. Because so that's why they always used to say, when you've created something, post it to yourself, because then there's a date and a timestamp. But because we live in a digital era now, you don't need to do that. You can just email it to yourself, and that already creates a timestamp for you. So even with the new technological advances, it will in effect work the same way, because what it will do is will create the certainty around the ownership and when that ownership was. And that goes to things like your NFTs. That's why a lot of people also like the idea of NFTs, because it's also a certainty on ownership of a specific within a specific asset on the blockchain. So now you've got that asset, you can prove the ownership, there is that stamp on when you owned it, and how many other people have owned it, either before you, after you, and when you transfer it, then you've got that history of ownership, right? So technology allows for you to create the certainty around the ownership. And then your second question, just repeat it for me. Okay, so I can't really say which technological advances are best, but you look at YouTube. They already flag if anything. So they've already got processes and systems and technology in place that if you upload a song, they can already flag it and say this is a copyright infringement because they've got those softwares and the server and the built-in service that identifies any sort of copyright infringement. So those systems do exist, and they are effective in the sense that, like I said, it's a certainty of who owns what, and it's a certainty of usage without getting the relevant license for it. So in terms of which ones are best, I really can't say which ones are best, because I think any sort of technology that works for you, depending on what it is that you're doing and how you want to identify what kind of information you want to extract from it. Because some people just want to use technology from just to protect their interests. Some people want to use it to extract the data. So now you want to know whether how many people are listening to your song in a particular jurisdiction, and what's the demographic of the people who are listening to your song, etc. And you take that, you build whether it's a performance, you build it around that demographic, knowing that my big market share sits in maybe somewhere in Cape Town, and the majority of the people who listen to my music are youth between the ages of 14 and 22, and they actually 60% of them are actually women, 40% are men. Now you know how to tailor make your either your performance around that. So it's more about what you want to use the data for, what you want to use the information for, and you can then you use what works for you, and that end goal. But I don't think it's necessarily an IP question. I mean, the data, you can own it and it becomes your data. But yeah. Okay. All right. Yes, I think that's the last question.
Hi, my name is Chloe. I wanted to ask something maybe about the scenario. Say I'm a producer, I'm a producer. So let's say, as a producer, you put the music together, the arrangement, the mixing, everything else. So let's say I bring a session musician, right? When a session musician, let's say I wanted to play like a guitar in like a melody, but then we in the studio working together, you have not talked about like the legalities on law. So then we make the song together. As a producer, most of the time, you own like your post-production, the artist comes and does the lyrics and then the own the lyrics and everything else. But now, in a case where you do not do the legalities, the song goes on the radio, it becomes popular, but I'm the producer and the song is mine, right? And you did the melody. So technically, it belongs to both parties to a certain extent. But now, what if there's like no content to say that in the guitar and the look like start production and I recorded it? What happens in that case?
That's why there's a lot of, I don't want to mention names, but that's why there's a lot of disputes around the Amapiano stuff, right? Is that because there aren't contracts in place, people all just jump in a studio, and I don't want to use this because somebody's sitting here and yeah, So all I'm saying is that if I'm gonna be in that studio with you and I'm contributing to the song and we haven't discussed any of the legalities, I can go and take you to court and say, but I paid the strings. There was actually a recent case where somebody did play the strings, and they discovered that the reason why the song was such a big hit was because of that guitar element, and that's why. And that person actually managed to get a bigger chunk of the share in the song because of just the strings. And I mean, they didn't play anything that wasn't long. It wasn't the biggest chunk of the song. However, it's what made the song. So so you have to discuss those elements. And if you say you're a producer, yes, you'll own the sound recording, you'll do whatever you're doing there. But still, I need to get my share in it.
But sorry, but when they calculate this chunk, they have to have in consideration the money that she spent on marketing the song and so on, because she also spent a lot of money on that. They have it in consideration, right?
You take a lot of issues are taken into consideration, but IP infringement is a punishment for the person who's infringed. So whether you've spent 1 million rand on marketing the song, you've used my IP. So I don't care about your million rand that you spent. Do you get what I mean? I'm spending 100,000 to fight this.
But okay, you fight it, that's fine. But when they are paying you back, right? Because I know I understand this, yes, fine. But when you are, because in her case, like they didn't have nothing, no contract, right? And I know it's not good to whatever, but yeah. But when they are doing it, they have in consideration what she spent, because she also paid this person to do the work, and then she also spent a lot of money to market the music. Otherwise, music would be sitting there with no success, anyways.
Still, my answer remains the same. Yes.
In a
Mm.
that session musician has an automatic right of
Yes.
remuneration.
Oh yes, yeah, yeah.
So
If you haven't
charge
paid
a
them.
session musician, no matter what you say, and this is not the right of the composition, but just performing in the studio from the recording, means that they will get paid a percentage of the sampling and stuff.
Mm.
That's just on the one side.
Mm.
If that's
Yeah. Yes. Okay, I think we're done. They're telling me that.
Yeah. It's a hard subject.
Yes. Okay. So yeah. That was it. Thank you.